Welcome back to Law Talk Moments, a legal program designed to help make the complex simple and to promote the practice of law, which I unapologetically consider to be a noble profession. I'm attorney Rob Caprera, and I'm humbled to be your host again for this program. Last week, we considered why we need the probate process. Simply, it is the recognized way that we prove our ownership in the assets that we inherit in estates. It's obviously an indispensable process because without it, the ownership of billions upon billions of dollars of assets couldn't be proven. Today, I'd like to answer a question that many clients ask or give as a complaint. Why does the probate process take so long? Granted, this is a legitimate question. Before Massachusetts adopted the so-called Massachusetts Uniform Probate Code in 2012, normal probate estates couldn't be closed until 9 months after the appointment of the executor or administrator. On occasions, when the will or family members couldn't be easily located, it could take many months before the executor or administrator could be appointed, and then 9 months had to be added to that late date. Today, under the Uniform Probate Code, we must wait until the passage of 1 year from the date of death. The reason for the delay in both the old and the new systems is to afford creditors the ability to become aware of the decedent's death and to have time to perfect their claims against the decedent's estate. But the looming claims of possible creditors can't tie up an estate forever. Once the 1 year date passes, then the creditor claims are forever barred. In effect, 1 year is the statute of limitations for creditors to bring a claim against an estate. Before the passage of that special 1 year, a personal representative can make distribution of the estate assets to the beneficiaries of the estate, but this is done at personal risk to the personal representative, because if all the assets of the estate are released out to the heirs before 1 year, and unfortunately then a creditor pops up and files a valid claim, the personal representative may not be able to reel the distributed assets back into the estate from the beneficiaries, and under this unfortunate circumstance, the personal representative would become personally liable to come up with these assets to pay the valid creditor. This is obviously a substantial risk placed upon the personal representative. And more often than not, the advice given to the personal representative is to hold off on making distributions until the 1 year period passes. Hence, the probate process minimally will carry on for more than a year in most situations. Then, if complications exist in the estate, for whatever reason, the distributions and final filings will get bumped out more months to the frustration of the clients and the beneficiaries. It's just one of those things. Creditors need to be justly considered in the probating of estates, and time needs to be given to them to perfect their rights. In estates under $25,000, the procedure referred to as voluntary administration can be used, and it is an expedited process whereby a personal representative could get appointed at a time at least 30 days after the decedent's death, and distribution of these assets could occur shortly thereafter. The risk of creditors filing claims still exists, but the size of the estate is much smaller, so the risk is not as big. In any event, the length of probate is dictated by statute, and the fact that an estate is open after 1 year from the date of death is not evidence of sloppy or inattentive work on the part of the personal representative or the probate lawyer, but rather it's the natural process working itself out in a prescribed way. As the saying goes, it's better to be safe than sorry, and patience is a virtue. This program continues our focus on probate law and probate practice. Thank you for following along with us. It's been a pleasure to serve you in this way. If you'd like your legal questions considered for future presentations, please submit them to www.capreralaw.com. And as always, thank you for listening and take care.